submission is that the interview list that will be published will contain the 10 marks.
And paragraph 6 is to be ignored because the
All
rule
right,
of reading is has to be said.
your submission is that the interview list will contain the 10 marks. This is your submission.
Interview list should contain.
Should contain. Just now you read out 8. It says subject to verification of credentials. The credentials have not been verified till date. How can the interview list be published?
That is new point argued.
No, it is you who placed this.
No, I have placed.
You have placed.
It is not done. Who said so?
The parties.
Who is not done?
Sir, your client has appeared in the written examination. Did you take instruction whether their credentials have been verified?
Please come.
They have not.
Please come back to the rules. Verification how to be done is also mentioned there.
This kindly give me 5 minutes. This all problems will be resolved. Give me 5 minutes. Give me 5. All confusing. Kindly give me 5 minutes. 5 or 10 minutes. Then kindly hear them. Give me 10 minutes.
Application.
Yes.
That will made as a type of filing a written test.
It has not been done.
Then written test list was published. And without verification.
Hey, this is the commission's way of functioning. What can be done?
No. We are not. Whatever Mr. Mitra is saying, that is no.
Kindly hear Mr. Bandyopadhyay.
Mr. Mitra's submission to this extent is not correct.
Certainly.
Let us hear.
10 minutes. This is just answering only this. Verification done at the stage of written test.
2 hours, they will take
It is
time.
formally done.
Let the commission say whether they have verified or not. Let us hear. Yes, Mr. Bandyopadhyay.
Kindly similar. I have 2 or 3 first the objections.
Yes, please.
The read petition is not entertainable by this court at this stage.
Right.
Because the read petitioners all appeared in the examinations.
Right.
And Miller, to this extent, I am citing a judgment, Miller, 2024 SCC Online 1511.
Yes.
Paragraph 6. Miller, may I read, Miller?
Yes.
The contentions of the appellant are not acceptable. This has in fact been dealt with the High Court. The conditions stipulated in the corrigendum is no more amount to a change of the rules as has been argued before. Moreover, the appellant was fully aware of the rules and those conditions under which he had participated. Once he has participated under a rule, he cannot challenge the rules to be unfair if the promotions have not been made as he would have wanted. This important aspect is the promotion have taken place as per. Now, once he has appeared, then Mallard, he cannot challenge the rules. Second point, Mallard. See, Mallard, just I tell you, very short, the fact is, in the Orunima Pal's case, entire rule was challenged. Now, Mallard, entire rule that was dismissed, here dismissed, even in the Supreme Court, it was dismissed, except in certain portion. Then, Mallard, successful candidates, I mean, untainted teachers also filed so many petitions in Supreme Court. Either challenging the Orunima Pal's judgment and other judgment, also Article 32. Supreme Court is examining the entire rule. And that is fixed on 24th November.
This 2025 rule?
Yes.
Nobody has submitted this.
No, they have not said.
I said, yesterday I did say. I
They said.
that
Now, what I would be...
Dismissed, but whether this rule is under...
Yes. Yes, Mallard, I will show. If your lordship give me time, I will.
Some saying no, some saying yes. What does the court?
Mallard, in that case, give me some time. I will show you the petitions also and whether there are some issues. Mallard, may I just take it from me, Mallard? Just take it from me. Please, Mr. Dasgupta, all you have taken time. My lord, the Supreme Court has said, kindly take it from me, on 24th November or whenever they met, entire thing would be scrutinized. Second, that is, I leave it to your lordships whether your lordships will examine it or not. I am telling your lordships the fact. Therefore, this is everything is under the scrutiny of the Supreme Court. Just I tell your lordships this. My lord, I will be requesting to your lordships that give a direction to move them under Article 32 before the Supreme Court because so many multiplicity of the litigations are not expected. Whole rule can be seen there. They can go under Article 32 also when this is being looked into. This is one of the part of the matter objection, and also it will not be rather proper at this stage by the High Court to go into this. Third is a delay. Well, delay maybe 1 year delay, maybe 6 days delay is also factor. If at all without waiving my submission that they cannot challenge the rule, they could have come earlier. They did not come earlier. Your Lordship was still observing just a change of determinant. That is the last week. 3 or 4 months, they have not challenged it. Today, we are going to publish the only candidates who appeared in the written examination with their marks. Nothing more than that. Thereafter, the verification will be done within 7 days. 7 days or 10 days, just take it, at that time, this is one group, only 11, 12 will be published today. 9 and 10 will be published within 2 or 3 days. But this argument I have also made in the Supreme Court also. Supreme Court has given us time, that's all right, you continue with this. Verification, etc. But then after verification, what stage is coming? Before interview? Yes, before interview. First, I have to verify that whether any teacher who has, any candidate who has applied and passed in the examination, whether he is eligible or not. Let's take it, there are some cases, we have given it, said it in the Supreme Court. Supreme Court has also given us the liberty. Some cases, maybe some tainted candidates have been missed. Let's just assume for argument's sake. But at the verification stage, we can also say, we can also detect them, cancel. Similarly, the untainted teacher who are claiming untainted teachers altogether, whether they are all untainted or not, that would be verified at the verification stage. After the verification stage is over, now let's kindly come to the rules. The losses have gone to the rules. Kindly come to page.
Sir, আপনি item number 2 না 3 তে বলছেন?
ভাই আমাকে তো যেটা বলছো যেটা চলছে লিস্টে দেখাচ্ছি সেটাই তো করছি। Anyway, subject is same. Inter 2K, kindly see 2K. Interview list vacancies. In the post of assistant teacher, a list of candidates prepared by the Central Commission to be called on merit for oral interview and lecture demonstration categorized on the basis of the preliminary merit score from written test and or TT for Amra so and academic score in the ratio of 16.1 final vacancies. And this academic score you will find here the policy schedule. Schedule 2. Along with the prior teaching experience. Therefore, interview this preliminary merit score and also academic score. Then you will also kindly see merit list. 2L. Merit list in respect of the SLC state level selection test means in case of post, a list of candidates prepared category-wise on the basis of merit, which shall mean, and in addition to what has been stated in Rule 2K, marks obtained in oral interview, lecture definition, and prior teaching experience shall include all the eligible candidates. That is a wide definition. And at the time of preparing of the merit list, we'll take into consideration all things, everything. That doesn't mean that the prior teaching experience is not included within the 2K, because it is within the academic. But that has been more clarified what Mr. Mitro was submitting under Rule 11K. Therefore, today before a lordship is 2K, today before a lordship is 2L, and today before a lordship is 11. That Mr. Mitro was submitting, that 11, Roman 8. The Central Commission shall prepare and publish its website a preliminary list with details of the candidates to be called for interview, subject to verification of credentials and eligibility, categorized on the basis of the preliminary merit score as defined in Rule 2(1)K in the ratio of 1.61. Malad, your lordship notes the rule of interpretation, there's a harmonious construction. And with the court object is not to destroy the rule. Court object is to preserve the iron quickly. Now, kindly similar, your lordship takes this chip very clear. First is written examination result, verification, then the academic score, Then it comes without the interview. Interview what? That's the two stages are there, oral interview and the demonstration is there. This is the case. But there I cite one judgment to your lordship. Only take this. Give it. The 2000, Justice Malami says, the 2024 SCC online 3776. SCC online 3776.
SC 377.
24 SCC online 377.
Kindly come to paragraph 6. The contentions of the appellants are not acceptable. This has in fact been dealt with by the High Court. The conditions stipulated in the corrigendum is no manner. Sorry, I am very sorry. Kindly excuse me, Miller. Kindly excuse me. I am very sorry. I am sorry. I have given a wrong citation and I was in 2024 SCC online 3776. Kindly come to paragraph 24. I'm very sorry. In state of Rajasthan versus Sannam Lodha, this court was considering whether absent a challenge to the law or rule, this same could be read down answering in the negative. Honorable R.B. Ravindra and J. So it is true that any provision of an enactment can be read down so as to erase the obnoxious or unconstitutional element in it or to bring it in conformity with the object of such enactment. Similarly, a rule forming part of an executive instruction can also be read down to save it from invalidity or to bring it in conformity with the avowed policy of the government. When courts find a rule to be defective or violative of the constitutional or statutory provision, they tend to save the rule wherever possible and practical by reading it down by a benevolent interpretation, rather than they declare it as unconstitutional or invalid. But such an occasion did not arise, and in this case, there is no challenge or to the validity of the Rule 5 so and so, and therefore of the view that in the absence of any challenge to the Rule so and so. Now let's come to the prayer of the petitions. Kindly see. Page 21. It is Shishir Das. A declaration. Kindly say declaration declaring that the respondent authority and its agents to abide by Rule 21K and Rule 21L of the West Bengal School Service Commission, appoint to so and so, and the rules to thereby awarding prior teaching experience after the interview round in connection to the recruitment process 2025. His interpretation is this should be done after the interview. Our interpretation of the rule is this, that it has to be done before interview. Therefore, he has not challenged the entire rule. He is asking the marks should be added after interview. And according to our rules, our interpretation is before that. Now, the next second, a writ of in the nature of mandamus to issue commanding the response their agents, servants, subordinate employees, and assigns not to award marks for prior teaching experience in calling a candidate for interview in connection to the recruitment process. Therefore, Millard, today, I don't know, Millard, whether what is your lordship's mind is, whether your lordship is finally hearing the matter, or, Millard, we have to file an affidavit, no doubt about it. And at this juncture, the question of passing of interim order does not arise at all. That will absolutely allow the writ petition itself. Millard, kindly remember one thing, Millard, we are running against the time. That is the whole difficulty we are seeing. Yes, that day also I was telling to a lordship's man. 31st December, I have to declare the result in terms of the Supreme Court's order. Millard, with great respect, I tell you, lordship, with great respect to your lordship, any type of intervention in this matter will nullify the order of the Supreme Court by 31st December 2025 as to be. And prima facie, I have a case I have shown to your lordship. This is the case. And I will request and beseech to your lordships. I will rather beseech to your lordships in this matter. So many applications, so many writ petitions have been filed. Why they are avoiding Supreme Court now? That's much I am telling you. With a guarantee I am telling, everyone is avoiding Supreme Court. Give them leave to file before the Supreme Court under Article 32.
Please,
any sorts of
document, please show me some document that this issue is pending before the Supreme Court and 24th is the date fixed for hearing of this.
In that case, kindly take it on 12th. I will show you.
Yes.
No, there are so many. Please show me.
The copy of the SLP is required to be produced before a lordship.
He's showing something. Let him show.
Let him show something.
Milord, I will show that the Orunima Pal's judgment, where Orunima Pal's judgment, the entire rule has been upheld by the division bench, was challenged by them.
This was placed
That
yesterday.
I placed yesterday.
We placed it yesterday.
I think should come to rest after. Because this 10 marks granting or not granting the division is held, and it is not arbitrary.
My points have not been dealt with in Orunima
That's
Pal,
a-
what I have said.
The question was whether that that particular rule was arbitrary or not.
Was the rule under challenge?
Yes.
One order from my CAN application.
You have a copy of the no, this order. Have a copy? Please check up.
Yes.
Page 24, this line was placed yesterday.
And then 634.
1 minute, please. Page 24. Sixth sentence, the recruitment rules has not been challenged by any of the appellants.
That is not
Incorrect.
probably not correct.
See, this is the court's order.
Yesterday it was shown to your lordship.
This
Yesterday it was shown to your lordship.
line was also
Lord, with
shown.
respect,
And in the single page,
they will to Mr. Bandyopadhyay showed it to your lordship.
Yes.
I wanted to
Right.
show the pair of Orunima
Lord,
Pal.
please see paragraph 28 of this division bench. Please see 28.
Was under challenge.
It was.
But thereafter not proceeded with.
Yes.
No, before the division bench,
There is a difference.
There is a difference
Yes.
between not challenging at all
Right.
versus
And
I
abandoning
challenge,
it.
thereafter just a second.
See the pair.
Challenge and thereafter I find I don't want to continue because of XYZ reasons which may not be suitable for me, so I give up.
Yes.
This was a case of given up, and that was recorded by the division bench.
my lord, all the councils,
Respect of one. In
my lord,
respect
kindly
of
see,
one candidate who's not a party over here,
Correct,
right?
correct.
So the court, when the litigant gives up the issue,
Yes.
the court doesn't have any scope and an occasion to.
Look into that.
my lord, that is your lordship is absolutely correct.
Correct. No
My
doubt.
lord, your lordship is absolutely correct.
Well, there
But
are-
what I am, my lord, that is your lordship is absolutely correct. My lord, whatever it may be, ultimately it will be decided by the Supreme Court. There, my lord, Article 32 petition is
after Mr.
Article 32 petition is
I
maintainable.
don't take soft copies.
Article 32 petition is also maintainable. They have moved so many Article 32 petitions.
What is pending in 20?
Because time is a very important factor here. That is the reason I am saying. Otherwise, I would not have argued this point to your lordship. Your lordship is having all jurisdiction powers, everything to examine whoever the litigant is approaching before your lordship. But here is a case, your lordship knows this, the entire thing, that if your lordship, then of course, if your lordship entertain the petition, we will file an affidavit, thereafter matter would be heard. But
No,
any
this is
type
a
of
point
interior,
of law. This is only interpretation. There is no affidavit to be filed because factually nobody is denying or
well,
disputing.
not only one thing, kindly record that I wanted to file an affidavit, but affidavit is not required. Your lordship makes this interpretation.
But according to me, everything is
Well, I have to put on record all these documents. What your lordship is saying, where is these documents, where are that other documents that I have to place it before your lordship.
the Bandyopadhyay is correct. Your lordship kindly come to page 41
Of
of my CAN 1 of Shishir Das matter. Item number 3.
can one din to dekhi.
Can one din na?
Page?
Can one.
Page 41.
Milord, with your lordship's leave, may I go, Milord?
দেখি শিশির দাস
কেউ যাবেন না?
No, Milord, with your lordship's leave, may I go, Milord?
রিট পিটিশনের নামটা দেখুন না
চলে যাচ্ছে কেন?
শ্রী দাস ক্যান ওয়ান এটা কোনটাতে
This is CAN 1, your lordship.
স্যার একটু থাকুন।
পেছনটা দেখুন শিশির দাস
But every
Milord, with your lordship's leave, may I go, Milord? With your lordship's leave,
price of the Supreme
can I go?
Court.
Can I go, Milord? With your lordship's leave, can I go, Milord?
yes Mr. বন্দ্যোপাধ্যায় certainly
Milord, deeply obliged.
Everything
all right
Two is completely different. I tell you.
1 minute some Mr. Sanyal was showing some 41
Sleep over page 41, 42. We have a look at 43 only.
yes 43
এর ড্রপ করতো?
Already put the next page, page 44. The last paragraph. The matter need not be listed on 31st October or 31st October. Even if specific dates have been given in any of these batch of matters, as they would necessarily have been heard together. We are informed that the results of the selection test held on 7th September 2025 and 14th September 2025 would tentatively be declared in the first week of November 2025. List on 26th November 2024.
26th is mentioned. 24th.
So, all these have been applied.
Oh, my lord.
Oh, 1 minute, 1 minute, 1 minute. Page 41 that you placed is a matter of Vivek Paria. Where is
Place that order yesterday also.
Vivek Paria? Was it placed? I cannot.
We have given a copy of
So because every matter, a bunch of matters were heard by Justice Bhattacharya, jurisdiction bench presided over justice. All points are
Because Orunima Pal has been highlighted. I cannot recollect that now.
Yesterday, Orunima Pal was highlighted.
Yes.
Division bench and several different. Vivek Paria, my lord, issue was whether there was a criteria 45% has to be
no.
45% or 50%.
Incorrect.
Challenging that division bench negate no the qualification fixed by the
Mr. Mitra appeared for Vivek Paria before the High Court.
Listen, thing is whether this 10 marks
no
prior teaching experience, this issue was hard.
From why not let the SLP copy of the produce whether this 10 mark issue is in challenge in those SLP.
Even yesterday, the law SLP copy.
Mr. Shanala,
Whether this 10 marks come down,
point of law grounds kindly sit down.
And
Showing one second.
an issue has been raised as to why do not you take it up before the Supreme Court, the whole thing.
Fixed shot. But in fact, this should go before the Supreme Court.
Oh, I didn't see you. I missed. Just
Well, he just now came, Milord.
My lord, and Article 35 petition was moved directly by one of the candidates. The Supreme Court deprecated, no, you go before the High Court first. And another matter, my lord, the High Court refused to entertain. Supreme Court said, no, you first decide. That is why, my lord, your lordship finds all are special leave petition, not a single Article 32. All are from special leave petition. Let the copy of the SLB, if their candidates are appealing,
in Vivek.
Let the copy of the SLB be produced before your
Vivek.
Yesterday,
Is it there in the file? All right, I'll check it up.
Point of law number 12, ground number 12. Now, other point, each point is pending before the Supreme Court. But legislature was asking that whether we are out of expiry of the panel appointed candidates or not. If so, they will be tempted. Now, this order
1 minute. 1 minute. Vivek, SLP, which ground and
ground number 12.
ground 12.
Number 12.
All right.
I put a tick mark for the loss.
All right. All right.
Yesterday has been given the SH of Orunima. Orunima was hard with Vivek. I will show you your losses there. It's a bunch of
Was Vivek's SLP given or not?
Look at all the matters are hard analogous.
No, but then is it in one matter only?
What happened? There are a bunch of petitions, hard and disposed of by the division bench. One SLP was taken together, another SLP was moved.
No, Orunima Pal's SLP was only restricted to certain points and Vivek was restricted to certain points.
The fact remains, Milord, the entire thing is pending before the Honorable Supreme Court.
The entire thing. There are issues.
Milord, this issue, the issue which is being heard.
Show me something.
Keep it on Monday and produce the document. Keep it on Monday.
The other points panel we are not.
But why will the court look? The commission is there to look into it.
No, I'm showing to your lordship that everything is before the Supreme Court. Right.
Yes, and the commission is the authority to see who are in the panel, outside the panel, all these things.
Point was asked in this petition. Justice Bhattacharya in the single bench said we cannot do it because Supreme Court is in.
Yes, whatever
Then
the
went on appeal.
Division.
Appeal court justice division bench presided over Justice Papabutu Chakraborty held the same view.
That has been challenged. That has been challenged by the list was challenged by tainted candidates. So we do not fall under those candidates. Completely different, my lord. Your lordship can consider the writ petition. It will be clear to your lordship.
yes.
It's considering about tainted candidates. Kindly see what was the issue, my lord. Kindly consider
Question of law. It's a question of law. Stated 10% of
yes, question of law. Then why it is pending before the Supreme Court? I also say it's a question of law.
And the operative portion you have the order.
Well, kindly read the order, the issues raised in that writ petition. Completely different.
No, their submission is that the commission is to see who are tainted and not tainted.
He is arguing that these sort of candidates are coming within the zone of tainted. Yes. That submission. So this is the same argument.
No, that is completely separate and nothing has to nothing to do with the 10 marks.
Now before the Supreme Court.
That is the eligibility factor which the commission will consider. Whether they are eligible or not eligible, that is not the issue.
It's different.
Qualifications, not these ones.
No, the Supreme Court has said
That's one of the another.
will be able.
Cannot be allowed at all.
Yeah, that is also an eligibility.
That's one of the points. The 2 points are involved.
So that the commission will see. That is not the issue.
They are arguing
That-
whatever argued before the law.
These are not very relevant. What is important is whether this 10 mark issue is pending before the Supreme Court. Please show. Yesterday. All right, I'll check it up.
My lord, may I?
And the issues also. In a very short and a concise manner. Otherwise, see the documents over here. Yesterday's.
My lord, see the judgment of division bench, where this point was teaching 10 marks were raised or not. Please see paragraph 6.
Which one? Which judgment?
So this is Showman's judgment.
Arunima Paul?
Yes, see paragraph 6.
This is 16th July's judgment.
Paragraph 6, I have shown it. Then paragraph 6, middle. Mr. Bhattacharya submitted because in the middle, it is submitted that prior teaching experience for 10 years was not an eligibility criteria in earlier notification. Moreover, the percentage of marks has been arbitrarily increased from 45 to 30. This is the second point, and made malafide make them disqualified. Other is in terms of now, similar when this matter comes up before the High Court, I mean to the learned bench, what they're considering, what they're saying. No, but I think court is being misled. Dako. Court hold court. Paragraph 34. Paragraph 34 can you see now?
Paragraph 34 has been placed yesterday.
Yes.
Today also it has been placed, and one line is also there that the recruitment rule has not been challenged by any of the appellants.
My lord, but it's not challenged.
It is written over there. The 6th line from the top, page number 24.
My lordship may look at from this point of view. It is possible.
Yes.
There are
Awarding of marks. Awarding of 10 marks is a weightage.
No, page 24. Page 24 of the judgment.
Page 24, yes, 24.
6th line from the top.
Yeah, lordship is absolutely correct. I've seen
24,
See,
yes.
what is passing through the court's mind?
Can I just conclude? I began. There are
The prior
just-
teaching experience is an
not this-
important factor. If prior teaching is an important factor, the experienced teacher may impart education effectively and efficiently.
Next line.
Recruitment rule 225 has not been challenged by any of the applicants. I'm not challenged, but argument was made.
Suppose it is not under challenge, somebody comes up with an
Not challenge, just see.
I have
See, madam,
yeah,
has not been
I have
challenged.
answer to that, and I don't want to take an extreme view. My lord, when
But
a
look-
rule particular acceptable, please. Let us not go back.
34 has been placed,
Just
Mr.
30,
Chatterjee.
30, 30.
I don't want
That
to.
is also Mr. Bandhavada yesterday has
I
placed
don't want to
everything.
say. I do not want. Please. I do not want to say in that way. Kindly see two things. I do think there is every possibility, because I'm not going to say I'm 100% confident, but my hunch is there is a possibility that the entire virus of the rule may not be challenged before the Honorable Supreme Court. This is true. At the same time, this is also true that this is a unique situation, unlike other SLPs and civil appeal, where because of a gigantic nature of impact governing the matter, the Honorable Supreme Court is, without using the word monitor, is effectively, I'm using effectively trying to see that my order is actually complied with. So therefore, I do not say that if anyone questions the virus, Lordship doesn't have power to enter it. I don't think. I think one can independently question virus, which is a purely point of law, possible, unless it is purely covered. But there is also a thing called a propriety. Now, when the Honorable Supreme Court, in a very unique manner, in this case, is trying to ensure it is complied with, what does it mean? It means we have delivered a judgment, that's the Honorable Supreme Court. Thereafter, X, Y, Z things were our directions. are those directions being complied with? Now, at that juncture, I do not say that it's legally, I would be able to say that Lordship doesn't have a power. Lordship has power. But even if Lordship has power, Lordship may afford to say, I don't want to enter at this stage because of propriety. It's not because lack of power. This is number one. Number two, if Lordship wants to see this, because something has to be before your Lordship shockingly wrong. There is a clear-cut judgment by the Honorable Supreme Court in 2024 involving this prior experience. It was by, now kindly have a look at there. This is, it's not page, no, it is not page. This is, kindly see, 2024.